name you have on the case and who I am, it's two different people.
You want to smile about it and laugh about it? Take him back. We'll call him out later. Take him back. You keep laughing. You laugh one more time, that's 30 days. Go contempt. Look it up. I'm not threatening you. Say one more word and that's contempt. 30 days. 30 days.
All right, everyone. Today we're looking at one of the most intense courtroom exchanges you're likely to come across. The individual in this hearing is a self-proclaimed sovereign citizen, and he might be one of the most dismissive and uncooperative defendants we've ever featured. From the moment he speaks, he refuses to stay quiet or follow basic courtroom procedure, almost as if he's daring the judge to lock him up. Judge Simpson doesn't let a single moment slide. Every time the defendant tries to talk over court or pushes personal theories, the judge brings him right back to reality. Sovereign citizens often believe the law somehow doesn't apply to them, but as you'll see, that belief carries zero weight inside an actual courtroom. Let me know your thoughts on this defendant's behavior in the comments. And if you like these courtroom breakdowns and legal deep dives, make sure to hit the like button and subscribe. With that, let's jump straight into this chaotic hearing.
Seems to be some confusion.
What's the confusion?
I've stated multiple times on the record that I wish to represent myself.
Well, I thought we got rid of that issue the last.
Yeah, I thought so too. I spoke to this gentleman right here and expressed my wish to represent myself as well.
All right. Well, if he doesn't want you, I mean, we'll figure that out in a moment. So, Mr. Styron, we're going to go through this again. What do we want to do in this case? You understand what you're charged with, sir?
I understand what the charges are against me, yeah.
Okay, look, you're going to have to give me straightforward answers to my questions because I've got to make sure that you understand certain things. I got to do certain things here.
From my understanding,
you understand, first of all, that if you do indeed direct, you want to smile about it and laugh about it, take him back. We'll call him out later. Take him back. You keep laughing. You laugh one more time, that's 30 days. Go contempt. Look it up.
Well, that escalated fast. I've got to say, Judge Simpson has a remarkable way of dealing with sovereign citizen arguments. Completely calm, completely direct, and absolutely no patience for nonsense. Honestly, it makes you wonder what these individuals think the end result is going to be. Does this defendant truly believe he's helping his case? Because from the outside, it almost looks like he's inviting trouble. He sits there casually, smirking like the entire process is a game, even though everyone else in the courtroom knows the consequences are very real. There has never been a sovereign citizen defense that prevailed here, so the confidence is puzzling, to say the least. If anyone out there understands what drives this movement or what this particular guy hoped to achieve, feel free to break it down in the comments. For now, let's see how he handles his next appearance, because it's clear he's not finished yet.
State your name.
my name is Thomas Styron. Living man.
Mr. Styron, you are before the court. You have elected to represent yourself. I do have to advise you that you have 3 counts against you. The first count is that of fleeing and eluding 3rd degree under the Motor Vehicle Code. Do you understand the nature of that charge, sir?
This is under the assumption that you're compelling me to identify as Thomas York Styron, the legal entity on this case.
I believe that you are. Do you understand the nature of the charge, sir?
I don't understand how the name you have on the case and who I am, it's 2 different people.
I have a complaint, Thomas Styron II. Do you understand that that individual is charged with fleeing and eluding 3rd degree?
So,
do you understand the nature of that charge? You just need to answer my question.
For the record,
take him back, and when he decides he wants to cooperate, we'll bring him back, maybe. I'm not threatening you. Say one more word, and that's 30 days. 30 days.
And just like that, another major turn. This man seemed determined to test the limits of his freedom. That 30-day contempt sentence honestly felt inevitable with the way he was acting. Judge Simpson even gave him a clear opportunity to answer a straightforward question, but he still chose to ignore it. It's as if he's intentionally rejecting every ounce of common sense. You can practically see the moment the judge gives him one final chance, and then the moment he throws it away. It makes you wonder what his actual goal is, because nothing about his behavior suggests he's trying to help himself. If you have any theories on what he's trying to achieve, if anything, drop them below. But for now, let's take a look at how he approaches a courtroom on his third return. Things only get more unbelievable from here.
Recalls the case, people of the state of Michigan versus Thomas Styron II. Mr. Styron, you are before the court on a felony complaint that does allege count one. And I'm going to presume, since you do not want to answer the court's questions, that you understand English and understand what I'm saying. You are before the court on 3 charges. Count one is the charge of fleeing and eluding third degree. Under the Michigan Motor Vehicle Code, that is a felony punishable by up to 5 years incarceration, a $1,000 fine plus court cost, and would require the Secretary of State to suspend your license for up to 1 year upon conviction. Count two is assaulting, resisting, and obstructing a police officer. That is a felony or high court misdemeanor punishable by up to 2 years incarceration and or a $2,000 fine plus court cost. Count three is a misdemeanor offense of operating with a license suspended, denied, and or revoked. That is a misdemeanor as indicated, punishable by up to 93 days, $500 fine plus court cost. Your vehicle could be subject to immobilization. Since you refused previously to answer my acknowledgement as to whether you understand that, I will assume that you understand what you're charged with. You are also entitled to be represented by counsel at this and all subsequent proceedings. If you cannot afford to hire an attorney would be provided at public expense to represent you in this matter. You are entitled, as indicated, to be represented at this proceeding, all subsequent proceedings, including your preliminary examination, and if the matter were to proceed by trial, you would be entitled to counsel. It is, as we have gone through the previous proceedings, the court's understanding that you do not wish to be represented by counsel, and that this matter will then proceed forth with you representing yourself. I have to advise you that in representing yourself, the court will make the presumption that you understand the Michigan court rules, those regarding both procedure and those regarding evidence. The court will not be providing any legal assistance to you during the course of those proceedings and will hold you to the same standards that I would hold an attorney representing or practicing before this court. So, with all of that, and with the court's understanding that you do not want to be represented by counsel, I will set this matter for its next proceeding.
You understand I'm the beneficiary, not the trustee, right?
That will be the preliminary examination. I will set the preliminary examination. Has discovery been provided to the defendant?
Your Honor, he was previously represented by the public defender. I don't know if they turned over the paperwork to him.
Does anybody from the public defender's office know whether or not the defendant has been provided discovery? Mr. Odetella. Thank you, sir.
Thank you. Your Honor, we have the discovery. I have not been able to share that discovery with Mr. Styron. I tried to speak with him and go over it, but I'd be happy to turn that over to him at the first available.
All right. If you would either turn that over to the court officer so that they can provide that to Mr. Styron so that he has the discovery. And if you could do that today, I would appreciate it.
Yes, Your Honor.
I'm setting the preliminary examination. Thank you, sir.
Yes.
The people would have their witnesses available June 11th. Set this matter for preliminary examination in person, June 11th, 2024, 9 a.m. That is before me. Defendant, as he was leaving the courtroom the last time, the court did find the defendant in contempt, sentenced him to 30 days. The defendant will serve that sentence. The court will sign the judgment of sentence regarding the contempt.
I don't understand how that's possible. Like I said, I'm
So
a
first of
man.
all,
I'm
watch your
gonna share. You're
language.
treating me as if I'm the trustee, or I don't want to partake in any trust fraud or anything like that. Is this a CESQV trust matter involved in this? Or is my social security number attached to this at all? Go figure.
Styron, or whoever you wish to be addressed as, I'd suggest that you watch yourself because there's going to be more time coming. You keep it up.
You're
You will
presuming
learn,
that
you will
jurisdiction
learn
over
how
me.
to conduct yourself appropriately in these proceedings in this courtroom and before me. You will not in any manner whatsoever
You're trying to
disrespect
compel me to be somebody I'm not.
or this
You
institution.
have no evidence
It will not
to prove that
happen.
I'm who you say I
You
am.
will not talk to me in that fashion.
In what fashion? I'm not the one being unethical.
Very good. You'll serve the 30 days. We'll see. We'll see him on the 6th. Bond continued.
Do you think 30 days was enough for the way he acted? Honestly, I wouldn't have been surprised if Judge Simpson added another round of contempt after those closing remarks. It's surprising how far someone will push their luck during a single hearing. To his credit, this defendant showed an unusual level of confidence, coming in completely committed to arguments and theories that hold absolutely no legal weight. But confidence without understanding can only take you so far, especially in a courtroom where the judge is responsible for maintaining order. Cases like this are perfect reminders that knowing your rights is important, but you need to know the real law, not a version invented on the internet. Watching Judge Simpson handle the situation was both frustrating and oddly satisfying, because you rarely see a judge shut down these theories with such composure and clarity. What do you think? Should he have received more time, or was 30 days the right call? Share your thoughts below, and don't forget to like and subscribe if you want more breakdowns and courtroom analysis. Thanks so much for watching, and take care until the next one.